Hi, I'm Nicolene.
Hi, I'm Robyn Shepherd.
Hi, I'm Johan and welcome to our podcast. We are attorneys practicing as such at Schoeman Law Inc. in Cape Town, South Africa. Today, we will be talking about evictions and spoliation, what they are and how they apply in our law. Now, a funny example would be where you have Bob, who has a neighbor, Steve, and Bob is an avid gardener and really likes gnomes and has quite a large collection on his front lawn. Steve is not very fond of his gnomes and one night decides to steal those gnomes. And what Bob can do in order to get back possession of his gnomes.
Yeah, I think that's a funny example, Johan, because I think every one of us sitting here knows someone who owns a collection of gnomes, and we can just picture that. But I think for us as legal practitioners, we see pretty horrific things, and I know the reality is that often we have people who would put or rent out a property, like a tenant. They'll have a tenant in their property, and then for legitimate reasons, an eviction process would be instituted because usually the tenant stops paying. And I think for the moment, the reasons for the stopping of the payment is irrelevant. But the point is, you have someone who's living in your property. You are potentially responsible for servicing the bond related to that property, and this person's not paying his rent, which means it's a knock-on effect that you're unable to pay your bond. And it also means that there's a knock-on effect in terms of the utilities. So it's not just about the bond, it's also the water and electricity and sewage and all these other additional costs related to property ownership. And often we then see that eviction applications, which is the next step to ensue, is successful. And from a horror story perspective, I think in my career personally, one particular instance comes to mind where we go through all the steps, we have the eviction order in place, we execute that order just for that poor paying tenant to literally break their way back into the property the very same day after the sheriff had been there and so on. So I think the lesson to learn, and we tend to only focus on that little last cusp of it, the lesson to learn is really for landlords or property owners to be super careful in terms of who they contract with, to do thorough background checks. And I don't think it's happening at the level in which we are smarter with what we are doing. Robyn, what has your experience been like?
I definitely agree with you. I think the relationship between a tenant and a landlord is a special one. I mean, ultimately, you are renting out some form of property from that landlord. But naturally, tenants aren't always good at keeping up with payment and they fall into arrears. And when that happens, the landlord tends to take matters into their own hands, and that ranges from either changing locks or cutting off electricity, water, whatever it is that property serves specifically for the tenant. The landlord really takes it a step too far, and in that instance, there's a breach, and the tenant has the option to then apply to the court for a spoliation order, and the court will grant it, and the tenant can then obviously enjoy the property to what it was previously before the landlord has taken these really drastic measures. But it does go to show, and it does happen very frequent, that landlords just go rogue. They go rogue, and it ends up being a really expensive action that has to take place. But on that basis, Johan, I was just wondering if you could perhaps explain to us the concept of a spoliation order and how it really serves as a legal remedy for tenants.
So, look, essentially, a spoliation order or amendement van spolie is a remedy that exists basically to retain possession. So it's in a situation where someone takes the law into their own hands, as in your example of the landlord deciding to cut off electricity or lock doors, without any court order or anything like that. Or in my example, where Steve steals some gnomes, that's taking away possession from someone. And in order to get that possession back, you can't just go and take it back. The tenant can't just go and break the locks and get back into the property. This is all situations where you're taking the law into your own hands, where what this mandement van spolie or a spoliation order actually serves for is that you approach the court to say, look, I had possession and my possession was taken away. But it's also a drastic remedy. So it's not something that you can do after 6 months of having possession having been taken away. It's something that you have to do immediately when your possession gets taken away. You approach the court, you give them the circumstances, and it's quite a quick remedy. So the court will usually put you in the position that you were before the spoliation occurred, so before possession was taken away. And in past examples, it would be the return of the gnomes, or in your example, it would be that the electricity has to be reconnected, or the door has to be unlocked to give free access and possession back to the tenant. So, it's in those types of situations where a spoliation order is really useful, and it's quite a speedy remedy for anybody caught in that situation. But, and I'd like to ask you a question back, Robyn. What specific requirements do tenants need to meet for a successful reliance on the spoliation remedy? And, what are some of the defenses that a landlord would be able to raise?
So the valid defenses are that at the time of the spoliation, the applicant did not possess the peaceful and undisturbed control of the specific thing that we're dealing with. And then secondly, that the disturbance from the respondent was not actually unlawful. It was a lawful one, and they followed proper procedure. And that the disturbance that occurred, for example, if it was not unlawful, this would be something in terms of a court order. So the respondent can use some form of court order that they obviously obtained from a court. Or that the applicant, in the case-by-case matter, allowed too much time to pass before making that actual application. And therefore, the restoration of control is actually not possible. So those are the defenses that can be raised. And then in terms of the Prevention of Illegal Eviction and Unlawful Occupation of Land Act, which is very long, but essentially the PI Act in terms of evictions. Nicolene, I just wanted to ask if you could explain the context of the lawful methods that are available to landlords, and how does this tie in with the PI Act?
Yeah, thank you for that, Robyn. I agree that spoliation, if you take the law into your own hands, is really a remedy that has a very limited scope for a landlord to fight. And if a tenant that has been deprived of the basics, water, electricity, or possession, and because you've done that, we need to realize that the remedy is there to avoid a situation where people take the law into their own hands. So with that, then I think there's a lot of misconception around the PI Act. There's a lot of, maybe even a lot of opinions that it's a long, tedious, often unsuccessful process. Now, I don't agree with that, because I think if your legal team that you engage knows what they are doing, and they ask the right questions when we take the instruction, well, in a much better placed position to tell you, listen, this is someone who's a repeat offender. And regrettably, we get tenants that make it a habit of basically conning landlords. I know it's a very strong term that I use, but essentially that's what's happening. And because we don't screen properly, we create an environment where these guys continue to do that. So often we'll see someone taking occupation and maybe even paying for the first 2-3 months, right? And putting down the really big deposit, and then they stop. So we often think that the solution to all of this is to screen and to ask for larger deposits, because hopefully that'll attract the right type of tenant we want in our property. But if you're working with these guys that make it a habit of doing this, they'll just, give you a large portion up front, and then there'll probably be some reason or excuse for where the balance can't be paid. And, then you're so far down the line that you think, but, he's paid half of it. Let me take a chance here. And often that comes to bite us. But the first thing that we have to do is we have to send an eviction notice or a letter telling the tenant, listen, you haven't paid. If you don't fix it by X date, in other words, by paying, then this is going to happen. And once the time is run out, then we can bring our application. But again, we need to be careful where we bring the application, if it's High Court or Magistrates Court, because remember, our Magistrates Court has an automatic right of appeal to the High Court, meaning conversely to the High Court procedure, you don't have to show that you have a good case to take on appeal. It automatically goes, whether it's a good or a bad case. In other words, if there are valid reasons for a court to re-adjudicate or not. And with repeat offenders, it's often better to pay a little bit more, but to launch your proceedings in the High Court from the start, so that we don't have that appeal scenario. And remember, the practical effect of that appeal scenario is that 18 months down the line, you have your order. This person is still in that property because you are waiting for a date allocation to be heard on appeal. And that's really, and we can't do anything about that, right? We can make applications, try and have it heard earlier. But I think the main thing about PI applications is being realistic, engaging with someone who's suitably experienced, and for us to look at bringing it in the correct forum from the start. Those are some of your key points. And of course, the application in itself is quite technical, because it concurrently runs a ex parte, unopposed process, along with the actual eviction. And in most instances, the tenant doesn't even react. And the misconception, the final one that I want to touch on before we start wrapping up, is really about knowing that the duty of security of tenure, in other words, for someone to have a roof over their heads, it's really not something that befalls on the private sector. In other words, the landowner. It is something that befalls government. In other words, if you have someone who you are trying to evict who will, and I'm not saying that they say they'll be destitute, someone who will honestly be on the streets destitute if you succeed with your application, that person needs to go to the local authority and follow the process where they are then allocated housing under that process. And often landlords, and regrettably, this is a very abused process. And landlords go into it not knowing that that can happen and that may cause a delay. So again, goes back to making sure that when you are dealing with an eviction and you have to go that route, move fast, make sure that you go to a suitably qualified attorney and try and learn from each experience that you have so that you improve your process of screening your tenants going forward. So, Johan, I want to ask you, considering all of this that we've said, how the wheels can fall off and it can take long to secure, what advice would you give landlords? I know we've touched on screening, we've touched on some practicalities.
Ultimately, the difficulty we find a lot of the time is it's not just to do with actually the eviction procedure itself. It's also to do, it comes right down to basics. And that is, when you enter into an agreement with a tenant, you obviously have a written agreement. A lot of the time it's a written agreement. It doesn't have to be. It can be verbal as well. But our advice is always that do it in writing and make sure that the terms are clear about what is the procedure that needs to be followed, because it can become very confusing and points of contention when there are terms in a lease agreement that cause confusion. So it's important to consult a legal advisor from the beginning. Now, when you actually get to the eviction stage, and we've touched on this, you need to consult with an attorney with relevant experience, having brought these applications. I mean, end of the day, you don't want to sit in a situation where you've now instituted the magistrate's court, and then 18 months down the line, they appeal and they're still in the property and it's just costing you money. And now you have to bring it in the high court in any case. You have to take into consideration what is going to be the most cost-effective way in the long run and what is the ultimate outcome that you want. A lot of the time, and what I've seen recently as well, is that they actually require tenants to stipulate what their alternative accommodation would be in the case of an eviction. And that's a very good clause to have in a lease agreement, because it obviously means that if you have to evict them, you can use that to say what they do have alternative accommodation. And therefore it makes the process go a lot quicker, because now they don't have an excuse or a defense for your eviction application. So it really depends. And, end of the day, the things that landlords need to consider is, do they know enough about the industry and what could go wrong to just enter into any lease agreement that they've maybe pulled off the internet or gotten from a friend or just put together themselves? Or, are they confident enough in the person that they're now allowing onto their property? The screening is very important, and it all comes together to culminate into what potentially might go wrong. And that's why, from our side, at least, it's important to consult with a legal advisor to give you the right knowledge and so that allow you to make an informed decision about it. And when it ultimately comes to, we hope not, but when it does come to bring an eviction application, it's important that you consult with an attorney, because they can guide you into what is going to be the most effective way to achieve the outcome. And I think that sort of wraps up what is involved in eviction and spoliation and how these remedies work. So, we'd just like to thank everybody for listening to us today. And if you have any questions, please do let us know. And please do like, share, and comment in the box below. We'll be happy to hear any suggestions for maybe more content that you would like. And please do join us for our next episode, where we'll be talking about interdicts, including those that the Americans call restraining orders. Thank you.